Start. In India, no fundamental right has given rise to so much of litigation than property right between state and individuals. Through the Supreme Court of India sought to expand the scope and ambit of right of property, but it has been progressively curtailed through constitutional amendments. The Indian version of eminent domain has found in entry 42 list 3, which says acquisition or requisition of property. Under the original constitution, article 19 1 F and 31 provides for protection of property right, and later they were repealed and article 300A was inserted. Accordingly, no person shall be deprived of his property save by the authority of law. However, regarding right to property, what kind of protection given by the US Constitution under Article 300A? For better understanding of Article 19(1)(f) and 31 along with constitutional amendments. Article 31(2) of the Constitution provides for compulsory acquisition of land. The power of eminent domain is essential to the sovereign government. The provisions of the Fifth Amendment to the Constitution of the United States is that private property cannot be taken for public use without just compensation. The principle of compulsory acquisition of property is founded on superior claims of the whole community over an individual citizen is applicable only in those cases where private property is wanted for public use or demanded for the public welfare. Accordingly, the right of eminent domain does not imply a right in the sovereign power to take the property of one citizen and transfer it to another, even or a full compensation where the public interest will be in no way promoted by such transfer. The limitation on the power of eminent domain is that the acquisition or taking possession of property must be for a public purpose has been expressly engrafted in clause 2 of article 31 or of the Constitution of India. No property shall be compulsorily acquired or requisitioned save for a public purpose. The Supreme Court pointed out in State of Bihar v. Kameshwar Singh case that Article 31(2) as it stood before the amendment did not expressly make the existence of public purpose a condition precedent to the power of acquisition, but it was an essential ingredient of eminent domain, and the clause proceeded on the assumption that acquisition can be for a public purpose. After a scrutiny of the authorities, Das J. in Kameshwar Singh case reached the conclusion that no hard and fast definition of public purpose can be laid down for its concept. It has been rapidly changing in all countries. He formulated as a working definition that whatever furthers the general interest of the community as opposes that particular interest of the individual must be regarded as a public purpose. The Sholapur Spinning and Weaving Company Act of 1950 enabled the government to take control of the property to Sholapur Spinning and Weaving Company. The question was whether the act was invalid as it did not provide for compensation. The government did not acquire the property, therefore government was contended that Article 31(2) providing for compensation did not apply since only clause 1 applied. Any authorized law was sufficient to deprive a person property right. As clause 1 authorizes any deprivation of property under authority of law, the learned Chief Justice would postulate that the limiting power thereof is correct by clause 2. The Supreme Court held that the Sholapur Spinning and Weaving Company Act 1950 was void. Article 31 clause 1 and 2 should be read together. So when there is deprivation of property, though there is no acquisition by the state, clause 2 applied and compensation becomes payable. Stop.